everybody. I'd like to start by asking a question, just so I can set the scene right. Is there anybody in the room who would be brave enough to say they thoroughly understand GDPR? Put your hands up, please, if you think you're in that category. Okay. Are there people in the room who think you've got a fairly good understanding of GDPR? Okay, that's really helpful because it'll allow me to judge the way to go about this. So the title is, What Does the GDPR Say About Data Security? I'll address that directly at the relevant time, but I do want to set it in the context of what GDPR is trying to achieve overall. A bit about us to start with. We're a Leeds-based but nationwide consultancy. We're not Johnny-come-latelys who just jumped on a GDPR bandwagon. We've been passionate about this for over a decade, working in this sector of data privacy and data protection for over a decade. 3 slides about the typical sorts of clients, but we walk right across the board. We've got a really dominant position in housing authorities. We've got a strong position in the charity sector. And in sport, some pretty well-known football brands up there. And in the commercial sector with organisations like Danone and Spear & Jackson, DP World. Our range is across consulting in all aspects of data privacy. So it's not just GDPR and Data Protection Act. It's compliance in general with the NIS directive, with PCI DSS, and with ISO 27000 standard of policies. Now, to set the scene, GDPR was regarded as necessary because the European Union had the view that people were no longer trusting their data to organisations, and as a result, that was a brake on the growth of digital technology. So they wanted to bring about a position where consumers felt more confident so that their data could be used for the benefit of everybody, not just for organisations, but the individuals themselves. And what's really important about this is it affects you as individuals in your own lives, as well as the flip side of the organisations for whom you work. It came about as a regulation, that's the R at the end of GDPR, which meant that it was going to be implemented pretty much consistently throughout the European Union, although each nation state does have the chance for a few derogations. And when the GDPR was enacted in the UK on the 25th of May as the Data Protection Act 2018, we exercised a few of those derogations. And they are pretty technical, but largely they simply reinstated some of the derogations that were in the 1998 Data Protection Act. It concerns natural persons, that being the legal term for living human beings. So the deceased are out of scope, and it's really important to get your head around the fact that when we're talking about privacy, it's the privacy of people and their data that we're talking about throughout this. It affects processors in a way that the previous legislation never did. Processors being organisations that have been appointed to carry out processing work on your behalf. And that includes most forms of IT activity in the form of hosting and data processing as a subcontracted activity. So it exposes organisations whose lifeblood is providing IT services to regulations that were not there, not affecting them in the 98 Act. It is largely based around the need to prove compliance. It isn't satisfactory to say, yes, we are compliant, we've done what we need to do. You need the proof that that has taken place. And that's a big change in the new legislation. It's policed in the UK by the Information Commissioner's Office, and they have some pretty hefty powers. You've probably all heard about the level of fines that are possible to be levied under the new legislation. But they also do an excellent job of publishing guidance and information on how to comply, best practice, and some of that best practice guidance is industry specific, so that's very helpful too. And then they publish regularly the offenders, a rogues gallery, effectively as a warning to us about the things that we shouldn't be doing. So, the core of it, what does the GDPR say about data security? Sorry, I'm just going to set my watch so I know where I'm going. The the most significant part of what GDPR says is in one article, Article 32, Clause 1. I'll give you the chance to read that, but the bit that I really want to dwell on is the bit I've highlighted, appropriate technical and organizational measures, because that sums up what the GDPR is saying about data security. And we have to unpack that and understand what it means, because it's pretty vague, isn't it? What does appropriate mean? And what is the difference between the technological and the organizational measure? Well, it's deliberately vague in a way because the legislation is trying to anticipate the growth of technology. So if it had, for example, been prescribing certain things, like you must use SFTP versus FTP or HTTPS versus HTTP, within a matter of years, technology will have moved on, and that advice or those prescriptions would have been irrelevant. So it's been deliberately vague, but therein lies the challenge. It also refers to the rights and freedoms of natural persons, and that's what underlies the whole purpose of the legislation, which is that we as individuals, as consumers, sharing our data with organizations, need to be confident that our rights and freedoms are not going to be a threat. Continuing the same article, it then does talk about some specifics, and these are now the sorts of things that you need to be thinking about. The pseudonymization of data or the encryption of data. The ability to ensure ongoing confidentiality, integrity, and availability. Great acronym there, CIA, easy to remember it. Now, we'll unpack that in a moment, but think for a moment about the last thing, availability. The GDPR does not literally say you must have a disaster recovery plan and you must have a business continuity plan, but that is implicit because it is required that data, if it is temporarily lost or taken offline, must be capable of being restored as rapidly as possible. That's the availability part of that, and that introduces the concept of redundancy of systems, of mirroring, backup plans, restore plans. So although it's not explicit in the legislation, it is implicit that you have to take all of that into account. Timely manner is something that crops up again. It doesn't quantify what is timely. Is an outage of half an hour acceptable? Is an outage of a day acceptable? It doesn't quantify it. However, the challenge and the target, of course, should always be to aim for 100% uptime so that there are no outages of any sort. And then it refers to the regularity of testing, assessing, and evaluating the effectiveness of those systems. So this is where the proof element comes in, that it's not sufficient to be compliant, you have to have a system of record keeping that proves that you're compliant. It continues in Clause 2 of the same article that in assessing the appropriate level of security, you will take account of the risk. Now, that's another important factor because the whole of the GDPR is risk-based, and it doesn't expect you to have 100% rocket-proof, bulletproof systems for every element of what you do. But if you're processing high volumes of data or information which of necessity needs high availability, or most importantly, information which is of a sensitive nature, such as criminal records or medical data, you're expected to have a higher level of concern for that data. And then it begins to describe, well, what would we regard as a failure? And it's this list: the loss of data, the alteration of data, the unauthorized disclosure of data, failure of data in transmission, failure of data in storage. Now, each one of these little words is an element of what the GDPR is saying about data protection. But this is where we need to get practical about it, because if you are running a corner shop, yes, you have responsibilities under GDPR, but you're not expected to have the same level of concern and budget to look after that data as you would, for example, if you're a bank. So the word appropriate is the word to bear in mind. Appropriate to the risk is what it means. Going to skip through some of the data protection principles because I think that sets the basis of understanding, but I'm not going to dwell on all of them other than the principle that directly affects data security. Technically, there are only 6, but the 7th one, which gets talked about as though it's a principle, is the concept of accountability. So I'll skip through these because we've got a slide on each of them, but that is the one I'm going to dwell on. The 6th principle is about integrity and confidentiality. And the 7th, although, as I said, it's not officially a principle, really sums it all up, because this is about proving that you're obeying the other principles. So, the first one, fairness and transparency. This is a really simple test. If you think about it from your own point of view and ask the question, A, would I be surprised to find what an organisation is doing with my data? Or B, would I be annoyed to find out what an organisation is doing with my data? If you say no to either of those, it's likely that the organisation is being fair and transparent. The organisation has told you what will happen with your data, you know what will happen with your data, you agree with what will happen with your data. The companies that get into trouble are the ones that don't explain it adequately or use data in a way that they hadn't said they were going to use it. You have to have a lawful basis to process data, and for a long while people got really hung up about consent, but consent is only one of 6. The ICO says there's no hierarchy to these lawful bases. It says no one is better than any other. You just have to pick the one that is appropriate. If you are conducting a contract or entering into a contract, you have a lawful basis for processing data to be able to execute and deliver on that contract, in which case you don't need to ask for consent. In fact, it would be positively confusing if you were to ask for consent, because you don't need the consent. And even if the consent was withdrawn, you would still carry on processing that data because you have a contract that you have to execute. Legal obligation is about some of the subsets of our legislation that, for example, put an obligation on organisations to report their data to Revenue and Customs. Vital interests, it's literally life and death stuff about somebody who's on the point of dying and you don't want to be held up by privacy legislation to find out whether they're diabetic. Public task is a relatively new concept. It provides for the functions of government and local government. And legitimate interest is an interesting one, which is far too broad to go into today, but it is the one that generally is getting used by a lot of businesses that say, we have a legitimate interest to process this data because it's what we do, and as long as you carry out a balancing test that balances your rights with the data subject rights, it's a perfectly good lawful basis. But even if you've established your lawful basis, the processing has to be fair, and if it's unfair, that you're in breach of the principle. And therefore, it's handling the data in the way that the data subject would reasonably expect. In other words, what you've told them you will do with that data. And even if you're lawful and fair, you also have to be transparent. And transparency, in many cases, is established by having a well-written privacy policy and making that privacy policy well known to everybody. Purpose limitation is the second principle, and the simplest way of summing this up is you cannot justify keeping data, personal data, just because it comes in useful at some point in the future. You have got to establish why you need that data and use that data solely for the purpose for which it was originally collected. Data minimization, third principle, is about collecting the minimum of data necessary for the purpose. And there's an example. Do you need a customer's shoe size to be able to sell them a concert ticket? No, you don't. And I have a real-world example of this from our organisation when we were working with a housing association, and this housing association was renting out garages to anybody, not just the tenants of their houses. They had more car parking spaces than they needed. And on their website, it asks sexual orientation. And you think, what has that got to do with renting a car parking space? And it's a classic example of only asking for the data that you need for the purpose. If you don't need it, don't ask for it. Accuracy. Now, this is an interesting one. Initially, a lot of people thought, well, does this mean I've got to run constant data quality audits? Does this mean I've got to constantly process address data against the postal address file to check its accuracy? Well, those are potential means, but largely this is achieved by giving the data subjects, us, the right to inspect data that's held and then correct it if it's deemed to be incorrect. But of course, you need the systems to be able to do that. Storage limitation is the fifth principle, and it is about keeping data for no longer than it is required. Again, the law doesn't say how long that is. Certain other laws do, like the contract law that says you must keep contractual data for 6 years or 12 years in the case of a deed. But basically, it's up to you to justify how long you need that data, tell people, and then adhere to it. And quite often that becomes a demand upon an IT department, because it quite often means that you need bulk deletion routines for deleting data when it's reached the end of its useful life. And of course it has close links to both data minimization and data accuracy, because the longer you keep data, the more likely it is that it will become inaccurate because it just decays. People move, change phone number, change email address, and it also links to data minimization. So we're on to the sixth principle and the really important one for the purposes of today anyway, integrity and confidentiality. Data will be processed in a manner that ensures appropriate security of the personal data, including protection against, and there's that list that we've seen before. So poor information security is going to leave systems at risk, and if those systems are breached in a small or quite often in a sensational way, there's a very strong chance of causing harm or loss to individuals. And that's where the ICO is likely to step in. And the first question they will be asking is, well, what steps did you take to protect this data? And if you've said, well, we've spent a lot of money on this, we've carefully planned it, we've documented it, it's just that the bad guys got around us on this occasion, you'll be treated a lot better than if you said, well, you know what, we haven't really thought about this, we haven't kept the systems patched, we haven't got a backup routine that we can rely on, we haven't got a disaster recovery plan. If you're in that unfortunate situation, the ICO is likely to get quite severe with you. And don't forget, of course, that the security measures are not just about avoiding fraudulent access, hacking, phishing, and so on. They're about the accidental compromise of data. So this is where systems now need to think about the human element, about how do we avoid exfiltration of data by people setting email forwarding? How do we avoid exfiltration of data by people using memory sticks and portable drives when they shouldn't be? And the use of mobile phones, of course, is opening up the opportunity for data to stray out of the corporate area of control. But fundamentally, from the point of view of IT people, this is about the protection of networks, servers, and the broader systems from deliberate attack. Encryption's a great way of ameliorating some of these threats, because if data is encrypted at rest and in transit and ends up in the wrong hands, the ICO will say, you have taken appropriate measures. Encryption is specifically mentioned as being an appropriate measure. So as a bare minimum, I'd be encouraging you to make sure that all laptops are encrypted. There's really no excuse not to anymore. Windows 10 built in BitLocker, so it's a free and effective way of encrypting the laptops. And organizations are consistently moving towards the encryption of their entire server data systems. Right, difference between technical and organizational ought to be obvious, but sometimes they're not. So some of the technical measures are the really well-known ones like firewalls, encryption, antivirus software. But the organizational measures are just as important, because quite often the human beings are the weak point in your organization's security. So background checking where appropriate, having policies and procedures that people understand and follow, having training, that's vitally important. That is one that the ICO will always latch onto. Let's see your training records. How much time has been devoted to your employees to train them in good practice? How many of them have read the procedures that they're supposed to be following? Simple lock and key is really important, particularly when it involves paper data. Paper data shouldn't be just left lying around. That should be kept under lock and key. But it extends to good access control into buildings, proper use of swipe cards, combination locks, restricting access to areas where people have no need to be. And some of the really simplest stuff is about things like having a clear desk policy, so that personal data isn't left lying around on desks or in the mail room, or even worse, on the reception desk, where it can be seen or stolen. And it's underpinned by carrying out regular risk assessments. We'll look at a bit more detail on that in a moment. And a critical one that often gets overlooked, there is a whole article in the GDPR, Article 28, which says that before contracting with an outside organisation to process data on your behalf, you must carry out due diligence on them. You must satisfy yourself that they will take as good care of the personal data as you would yourself, and the contract that you write with them now has certain mandatory clauses that weren't there before the 25th of May. And those clauses are vital, because otherwise you are contracting with those people unlawfully. That's completely new since the 25th of May and is often overlooked. And then the seventh so-called principle, although technically in the way the legislation is drafted isn't actually a principle itself, is basically saying prove that you are obeying Articles 1 to 6. So that you must be able to demonstrate compliance, you must be following a data protection by design and default approach, of which we'll have a look at in a moment. Make sure that you've got written contracts in place with your processors and any other organisations where you jointly control data. Appoint a DPO. Now, certain organisations, that's mandatory, but if it's not mandatory, it's still good practice. That is something that can be outsourced. That's part of our business offering, that we are the outsourced data protection officer for quite a lot of organisations. And you really should establish a working group, an information security group, a GDPR group, an information governance group, whatever you call it, because that's part of proving that you take the subject seriously. Critically important from the point of view of the outside world is making sure that you have a properly written privacy notice, and then that you stick to it and you only do the things that you say in your privacy policy. And I was also asked to talk a little about data breaches. And so a vitally important part of this accountability aspect is that every single security breach, no matter how trivial or no matter how hypothetical, should be investigated. Some of them do turn out to be a breach and they need to be documented, but even the ones that don't turn out to be a breach and they're just classed as a near miss should be investigated, documented, and the lessons learned and systems and procedures altered accordingly. And underpinning control of the data, you really must make sure that you have a thorough understanding of all the elements of personal data in your organisation documented in an information asset register. Very similar to what the finance department would have had in a fixed asset register for many years, very similar to what most IT departments have got in terms of IT equipment in a register. Keep a record of all your data assets in an information asset register. And a biggie in accountability is sticking to your retention rules. Organisations have been fined in the past not just for having lost data, but having lost data which their own privacy policy said they shouldn't have been keeping in the first place. So they get fined twice. Right, demonstrating compliance. Now I'm going to skip through about the next 6 slides quite rapidly because all that these are on the right is extracts from our template information governance framework, a comprehensive set of policies and procedures that you can adapt, organisations can adapt to suit the needs of your organisation, but it takes the slog out of it because we've spent many months putting this set together, and this becomes part of your compliance. So an information security management policy, well, that's critical, isn't it, if you're trying to say we are taking our data security very seriously. I don't propose to read it all out to you, and you'll get these slides later, but it's basically just going to say, these are the people responsible, this is what we do, and this is how we police it. You will then have a set of specific IT policies, such as this is our information system acquisition policy, this is our information system development policy, our testing policy, our maintenance policy, how we apply patches, how we monitor the security logs. Without the documentation, the fact that you're actually doing it is only part of the requirement for compliance. You need to be able to prove it. Physical security, I've already mentioned this, but you may well have locks and keys on your doors. You may well have access control, but you need to be able to document who is in control of setting the access policies, who has got rights, what happens in exceptional circumstances, what happens when a key man is off ill, what do you do to justify that somebody needs to stand in for him in his absence. This all needs to be documented. If you're running cryptography, you need to explain how that cryptography is applied. And a critical thing for those of you that are already encrypting data is you'll know that keeping the keys somewhere where they're safe but accessible is an important part of recoverability. And then what do you do in the case of a breach? It's no good running around saying, we think we've had a breach, whose responsibility is this? Do we call IT? Do we call HR? Do we call our accountants? Do we phone our insurance company? You need a plan so that when it happens, you've got a smooth and pre-planned response to it. As I said, you need a disaster recovery plan and a business continuity plan. The two being distinct in as much as the disaster recovery typically is about localized situations, the loss of a server, the loss of part of a building. But business continuity is, well, what would happen if we had to evacuate our entire building for a month? How do we carry on? So, turning now to breach reporting. The definition of a breach is documented in the GDPR as being any one of those things. And of course, the critical thing is to spot that it includes accidental as well as deliberate. So if somebody accidentally loses a memory stick with critical personal data on it, that's potentially a breach, just as much as if you've had a malicious attack from hackers. This slide from 2016 is straight off the ICO website, and the only reason I didn't update it for this presentation is when I looked at the 2018 slide, not a lot had changed. And if you look at some of the detail of what is happening, am I still all right on the radio mic? Loss or theft of paperwork, simple as that. That's the human thing about people just leaving paper on a train. And data posted or faxed or emailed to an incorrect recipient. Personal data that was sent to somebody who had no right to receive it. Insecure web pages, including hacking. That, of course, is now climbing up the list, but it still hasn't exceeded the loss and theft of paperwork. It's remarkable how the human being is always the weak point. Insecure disposal of paperwork, I didn't mention that, but having secure shredding capability is a vital part of an information security plan. Loss or theft of an unencrypted device is a breach, but as I said, if it was an encrypted device, it wouldn't be a breach. So encryption's a great thing to be doing. And then under the incidents by type, you can see a pattern here that if you analyze those, there's more that are to do with human beings than there are to do with IT systems. However, the policies and procedures should be making sure that both are treated equally. Right, when do you have to report a breach to the ICO? Well, there's a word highlighted here, risk, and on a subsequent slide, there will be two words highlighted, high risk. If the loss or damage or theft of data is likely to present a risk to the rights and freedoms of individuals, you need to report that to the ICO. And you now need to report it within 72 hours. If you fail to report it in 72 hours, that's likely to be treated as a separate failure and might lead to a separate fine. Risk to the individual is for you to define by carrying out a risk analysis. This is the one with high risk on, because if you have suffered a loss or theft or damage to data that presents a high risk to the individuals, they need to be informed directly. Now, the high-risk areas are where you've lost things like bank account details, medical data, criminal record data, things that can cause real harm and damage to people. That needs to be reported to the individuals themselves. However, all of this needs to follow a plan. You need to be prepared for it, and you need to have a checklist or a flowchart that says, right, this falls into this category, this is what we have to do about it. Underpinning all of this, we encourage organisations to exercise a fair blame principle. I worked with a client, which has to remain nameless, where when I turned up, I said, have you ever had a data breach? And he said, 1 in 10 years, we lost a laptop. I introduced this fair blame principle where employees are encouraged to report anything that they regard as a possible loss or breach, and thanked for it, because the alternative is people are frightened of reporting it because they think, well, I've obviously committed a blunder here, I'm likely to come in for disciplinary action, could even be sacked for it. Well, we say, if you bring in this fair blame principle, you will get to know about what's going on. And that organisation that said we've had 1 breach in 10 years had 8 reported breaches within the next 3 months. Now, that means that they were in a position to do something about it. They were in a position to analyse what was going wrong with their policies and procedures and take some action accordingly. So you can't properly have a breach policy without having a fair blame policy. So the caveat is that we won't take any action against an individual unless they acted illegally, maliciously, or recklessly. If they merely committed a mistake, there is every chance that it is your own policies and procedures that are at fault as opposed to the individual. And therefore, they should be encouraged to bring this sort of thing to your attention. So, breach reporting. Get a policy out that everybody knows and understands that includes fair blame. Have a procedure and continuously refine it. You should be practicing breach on a monthly, quarterly basis, because the last thing you want is to come at the wrong time when half the senior staff are on holiday or your in-house lawyer is away on a conference abroad. You need to be able to cater for any situation, and particularly to have continuity in the absence of some of the key players. Encourage all your staff to report all security incidents, no matter how minor, because the minor ones could actually be the portent of something much more significant to follow. Ensure that everybody on the response team understands their responsibility. It's no good just appointing people and saying, right, the response team is going to be the in-house lawyer, the IT manager, the finance director, and the guy from compliance. That isn't sufficient. They all need to know, well, what do I do as part of this team in the event of a breach? And what would happen if any one of that key team is on holiday or at the other end of the country when they're needed? Plan and role-play all the possible scenarios. What would happen if we lost a critical laptop with some personal data on it? What would happen if we came in one morning and we were subject to a ransomware attack? What would happen if we came in one morning and our primary website is down? Role-play all of those scenarios so that you know what to do if it actually happens. Now, I can't spend the time to take you through this BBC News article here, but it's great, because it's a fictitious example of how not to do it. And it's some of the things I've just been describing. Does anybody know where the lawyer is today? Yeah, he's at a conference in Switzerland. Well, can we get him on the phone? Don't know his mobile phone number. You know, basic stuff like that. If you're part of a response team, the response plan needs to know how to contact people, because Sod's Law says it'll probably happen in the middle of the night, happen over Christmas, when people aren't actually expected to be in the office. Do encourage you to look at that, and when you get the slides, you'll get the hyperlink. And most importantly, learn from all these security incidents. Take them back to the Information Governance Steering Group and say, right, well, what have we learned from this? I was doing one of these only yesterday, where email forwarding had been set up without authority, and emails were being forwarded outside of the organisation to a Gmail account. Well, we first of all had to work out how and why, And was it malicious, or was it just an employee thinking that they were doing the right thing to be efficient? And when we concluded it was none of those, it was actually malicious, we had the learning exercise of what to do. Well, one of the things that came to my attention was that if you're using Office 365, the moment email forwarding is set up, it does send an alert to the control panel of whoever is running 365, but it comes through as a low priority alert. So one of the things we've learned, because that's a classic case of exfiltration of data, is change the level of that warning from being a low-level alert to a high-level alert. That's the learning process, so that if it were to happen again, it goes ping at the top of your screen, somebody's set on email forwarding. Who and why? Because we don't authorize that as an organization. And respond rapidly. You've only got 72 hours to report a breach from the point when you first become aware of it. That's slightly different from the point at which it first occurred. It might have occurred a month ago, but you've only just become aware of it. And the clock starts ticking from the moment you say, I don't like the look of this, we've got a problem. Now, you probably won't know all the facts at that point, but the ICO says report it anyway, and report the other facts as they become apparent in phases as you learn more. So, this is a really important policy and procedure that you need. You need the policy that says what you will do under certain circumstances, what the organization will do, and then you need the procedure which addresses the specific roles of everybody on the response team, so they all know what to do, and they don't run around like headless chickens saying, I don't know, I wasn't prepared for this. They must be prepared for it. I'm running short of time, but let's just throw all of these up on the screen. Are these breaches? Your house is burgled and your work laptop is stolen. Well, if it wasn't encrypted and it contains personal data, that's a breach. If it doesn't contain personal data, okay, you've got a security incident and you may well want to report it to the police as a theft, but it's not technically a breach if it didn't have personal data on it, and if it was encrypted, you've taken adequate technological measures, so then it's not a breach. And that's why understanding what constitutes a breach is really important. I'm not going to dwell on all of these, but this is a typical one. Sadly, this happens more than it should, that just because you can doesn't mean you should. Just because you've got access to the server with the CCTV images on it doesn't mean that you should go looking through it for purposes of your own that are contrary to the published purposes, which are likely to be for the protection of employees and the avoidance of crime. So looking through CCTV images for a purpose that you've not declared in your privacy policy is technically a breach. Now, it may or may not lead to a risk to the rights and freedoms of the person whose images are being viewed, but technically it's a breach. And then you've got the top right one, which is a really complex one to work your way through, because you get into the situation of what can we and should we do during a recruitment process. That's a fine art of its own, of understanding how GDPR affects that. But then you lose a notebook with personal data in. Is that a breach? Probably. But you've sent your notes to your Hotmail address. Is that a breach? Well, it probably is if your organization says we don't allow people to use private email accounts for business purposes. The individual there might be thinking they were doing a really good job of making sure they've got a backup. But if the organization says we don't permit that, that in itself is a breach because the information has been sent out of the control of the organization. And this one happens so many times, particularly amongst salespeople, that they change jobs and take their Outlook address book with them. A clear breach. It's happening all the while. And organizations have got to make it known to their employees that this will be treated as a criminal matter as well as a breach. It's theft. It's as simple as that. CCTV is a minefield, and there used to be an exemption for the use of CCTV on domestic premises. It's now very much part of the regulation that even domestic CCTV gets caught, but that's a subject in its own right. I just wanted to put that up as an example of capturing your neighbor on walking down a public footpath. Is that a breach? Technically it is. So be proactive about breach and avoidance of breach. Two ways of doing it. So I got about 2 minutes more. Oh, excellent, thank you. There's two ways of doing it that are listed in the legislation. One is data protection by design and default, Article 25.1, and the other is by carrying out risk assessments, data protection impact assessments. So again, we've got this phrase which crops up again and again in the legislation, appropriate technical and organisational measures. But basically, this is an area now where IT departments really do need to get involved in this process, because to be able to have a system that has data protection by design, it clearly has to be taken into account right at the start of the design or the procurement process. It's not sufficient to be an afterthought. You cannot any longer say, well, we've bought this system, we're halfway through implementing it. By the way, has anybody checked about the data protection aspects of it? Are we happy about that? You can't do it in that order anymore. There has to be an evaluation of the data protection elements before new software or administrative systems are implemented. And the bit about default is that data protection should always default to the safe condition. So for example, if you've got a screen that's got some core data like a name and address, and over on the right-hand side might have medical data or criminal record data, the default should be that nobody can see the right-hand half of the screen, other than through your RBAC controls, where you say, well, there's 3 individuals that have the right to see that, and you turn it on for them, as opposed to turning it off for everybody else. So that's the default about data protection by design. Just covered some of this. Such measures shall ensure that by default, personal data are not made accessible without the individual's intervention. So this is a responsibility, of course, of software vendors now, but it also becomes the responsibility of anybody buying software or designing their own software to make sure that it fails safe, it defaults to the secure condition. Data protection impact assessments are required by the legislation before any major steps are taken involving the use of personal data. And this affects business processes as well as the implementation of software. But really importantly, before even finishing the shortlist of vendors for a new system, you should be carrying out a data protection impact assessment that says, well, if we go ahead with this, what are the risks to the rights and freedoms of the data subjects whose data will be held in that system? On the right is another extract from our information governance framework, where we provide a checklist that effectively enshrines the requirements of the legislation into a simple procedure. So it's to evaluate the risks in either projects or the purchasing or design of new systems. First step is, does it involve personal data? Because if it doesn't, it's out of scope. But if it involves personal data, there are certain things you've got to do. And the steps are not particularly complex, but they'll always be risk-based. So if you're entering into areas of sensitive data like biometrics, facial recognition, then you need to be doing certain things over and above what you would be doing if you were dealing with standard personal data like name and address data. And then you measure the impact it's likely to have on the individuals. You may conclude it will have no impact, or you may conclude there is a risk here, we need to quantify that risk, we need to be aware of it. We may need to make a judgment that can we go ahead with this, and in extreme circumstances, the likes of which will only affect a small proportion of businesses in the UK, you actually have to get the permission of the ICO before proceeding. But that's likely to be large volumes of criminal data, Department of Justice data, that sort of thing. It doesn't generally affect the commercial use of data. And above all, you're measuring, well, is this going to be intrusive? Is the data subject likely to be surprised? Are they likely to be annoyed? 2 of the tests I mentioned earlier. And if they are, we've got to do something about it. We've either got to mitigate the risk, or we've got to flag it up and conclude that we live with it, but make the data subject aware of what is going on through the privacy notice. Right, I am coming to the end now, but I just wanted to mention about finding help on this subject. The ICO, sorry, I've clicked the button twice and it's not catching up with me. Well, I can do it without the slide. Oh, it's jumping. I'll carry on talking. I hope the slide catches up with me. The ICO is probably the simplest and most direct source of help on this. There's great advice and guidance. It's a very searchable site. But there are some other sources. The European Data Protection Board provides in-depth guidance about specific subjects, and their information is available freely on the internet. A lot of the big legal companies have produced some great stuff. Pretty generalized, of course, they have to be. But there's some good stuff that have come out from the top-level lawyers. Industry bodies, depends what industry you're in, but for example, if you're in marketing, the DMA, the Direct Marketing Association, is absolutely at the forefront of this. They do some great stuff. Other industry bodies, I think, are catching up. But the legislation does allow for accreditation schemes across named industries. So in the case of the DMA, if you abide by the DMA's code of conduct, then you can pretty much say that you are processing lawfully and in compliance with the legislation. There's always, of course, organisations like ours, but that goes without saying. And I left till last the scale of the penalties because I've never been one to use fear, uncertainty and doubt as a tool in this. I believe in being proactive. But it is worth being mindful of the scale of these potential fines because they're, in the most egregious cases, they can be up to 4% of global turnover. So the organisations like Facebook and Amazon are at risk of enormous fines. But generally speaking, the ICO would rather come and give you guidance. They would rather say, I can see you're doing your best. I can see that you take this seriously. I can see that you train your staff, that you've got policies, you've got procedures. This was just unfortunate, so we're going to put an enforcement notice on you, which demands that you correct the problem, and we'll come back in 3 months and check that you have corrected the problem. They're not likely to hammer you with fines if you can prove that you're doing the right thing. But bad PR is the thing that comes from all of this. TalkTalk have had a real problem of recovering from their major breach. British Airways have had their troubles in the last month or so. And then, of course, there's the cost of a cleanup. They're pretty significant. Some of these restorations of systems in the case of a bad attack can be very expensive. And we all see it in the press every day. Dozens of occurrences of this, Equifax, Mumsnet, you see them all. And some of them are breaches caused by malicious activity, like hackers, and that's therefore part of the technical security measures. But sadly, a lot of them are basics, like people having data on a memory stick that should never have been there in the first place, and then leaving it in the back of a taxi. So you need to be aware of both. But as I said, you're more likely to get an assessment notice from the ICO. The ICO has now got powers of entry and inspection, which was tested during the Cambridge Analytica situation, because I don't know how closely you followed that on the news, but you may recall that after it was aware that there were problems and the ICO was going to investigate, they had to go to court twice, and there was a 72-hour delay before they actually got on the premises. Well, they've learned from that and said, no, if we think there's malpractice going on, we want to knock the door down immediately and not wait for 72 hours. So they do have enforced powers of inspection and entry. But they'll always exercise those on a case-by-case basis. There isn't a guidebook for this. There isn't a rule book that says a certain type of breach will incur a certain type of fine. It'll always be assessed on a case-by-case basis. And that at the top sort of sums up. This was Elizabeth Denham saying, issuing fines has always been and will continue to be a last resort. So don't be so much frightened by the scaremongers talking about the high level of fines, but do think about the risk to reputation and do think about the cost of a clear-up. And that's me. Any questions? Well, the answer is, as long as you've got a policy and you abide by it, then you can do either. So you might have a routine that is looking at the creation date of a record and say, right, 5 years have expired, or more likely to be 5 years since the last transaction on the master file. It's time this record was deleted, and that might be a process that's running routinely. It might be stored procedures in SQL that does it in the background, and the records are just killed off or anonymized by blanking out the personal data. Or you might design a batch run that says, okay, every month end, we're going to just blast through the whole file and kill off all the old data. And the good analogy is what you would do in the case of paper records. You wouldn't expect your office admin staff to go and look through the entire filing cabinet every day to say, is there stuff in here which we should be deleting? You would probably say, well, at the end of the financial year, once we've got everything processed, we'll take the 5-year-old files and destroy those. So if you think of that as the analogy, it basically informs what you do in the case of IT data as well. Oh, bring your own device is a minefield. Best practice generally would be don't allow it. But of course, we know that a lot of organizations are thoroughly encouraging it, particularly organizations with hot desking, and organizations that say, we don't want the cost of giving everybody an iPad and a mobile phone, we'll allow you to use your own. But the real danger is that if you're going to allow bring your own device, is to make sure that you've got clear rules and they are policed, because it is a minefield. If you've got corporate data on somebody's mobile phone, there's every likelihood that if they're not sufficiently savvy, that phone will be backing up to iCloud or Google Drive or whatever without them even being aware of it, because it's the default setting when they buy the phone. So suddenly your corporate data is not only walking around in your employee's pocket, but is in Google Drive or iCloud. And that has incredible ramifications for data retention policies and for what you would do in the case of a subject access request. Because technically, you're supposed to search every location where that data might exist, and now you're having to search people's personal Google Drive for it. So it is a minefield. But basically, it's about thinking through the ramifications and setting a set of rules, and combine that as well with mobile device management systems so that you can do remote kill. It is a minefield. If you can ban it, ban it. But if you're the sort of organization where it has to be permitted, just make sure it's regulated. Okay? Any more? Well, I'll be around for the rest of the day, so if you have any more questions later, please let me know. Thank you.